Hello and welcome. My name is Marc Blatstein, the physician founder of Physician Pre-Sentence Report Service. This YouTube is centering around restitution payments, but the extreme end of having huge restitution to pay. And I'm going to start off with an article. It's Lisa Legal, their foundation. They review federal criminal law, federal criminal procedure, criminal justice legislation, and they stay on top of pretty much everything having to do with criminal justice, prison reform, et cetera. And they state that, or they write that there's been a sentiment enshrined in federal law as the abatement ad initio doctrine, which holds that a trial conviction is vacated once the defendant dies, or before he or she can exhaust the direct appeal process. But the First Circuit recently argued that they should begin to break new ground by holding that a defendant's conviction should outlast his death and does not get wiped away just because he or she dies before the appeal. And this was taken up in a Reuters article. And it is their opinion that when vacating the conviction and restitution order should be when a defendant dies while his or her direct appeal is pending, would flout a clear congressional directive. The government contends that when a defendant subject to restitution order dies, the individual state will be held responsible for any unpaid balance of the restitution amount. And the idea of this article is that going a bit too far because you're holding people responsible for a verdict or a debt that they had nothing to do with. At least that is my understanding of this particular article. And so there has been a together the National Association of Criminal Defense Lawyers and Ladies of Hope Ministries has partnered together to draft what's called a Fairness and Restitution Act. And so while this is not law currently, it may be something, depending on the amount of restitution that you have, for your attorneys at sentencing to, or to consider before sentencing, to phrase this, because it's not a law, as a request to the court, in addition to the other requests that that you will be making. And it has three sections. First is ensuring fairness, proportionality, and the accuracy of the amount of restitution owed. And so and it makes sense to request that the government show that it's the actual loss sustained by the victim as a direct proximate result of your actions or the defendant's actions. Makes sense? Eliminate joint and several liability and ensure that the defendants are only responsible for the financial losses that they themselves caused. Last, to provide right of an evidentiary hearing for proving or disproving the amounts included in their restitution order. And again, this is all framed, because it's not law, but in a request dialogue with the court. Second goal, preventing restitution obligations from becoming overly onerous or lengthy. Changing the statutory period of liability from 20 years to 10 years and prevent extensions, which are not authorized under current law, but often permitted by the courts. Meaning that it's not authorized to have a 20-year extension, but the courts often allow it. Allow the courts to consider economic circumstances of the defendant so that defendants are not burdened with unfair and unrealistic restitution requirements. Now, I'm going to lump this with the next one. Prevent the seizing or garnishment of wages, benefits, or certain other amounts if it would render the defendant poor enough to qualify for the appointment of counsel under federal guidelines. So my take on this is a little bit different. I'm not a lawyer, but to take all of the money that is needed for the restitution or to force all of that from the defendant, enough to push the defendant into welfare, into basically poor enough to have to go on welfare and not be able to get employment, just makes them essentially another financial liability of the government, because they'll be paying for his housing, his food, his medical care. And so that doesn't seem to provide a win-win for everybody. Just a thought. Allow defendants to petition for a change in the restitution order if their economic circumstances change. Correct. If it gets better, they can pay it. Helping victims recover while helping defendants avoid burdensome debts. Require that any amounts collected by the government first go to satisfaction of a restitution order. Meaning that right now, my understanding is that while restitution payments are being paid, there's no real paper trail to show that the victims are actually getting the monies in cases where both restitution and forfeiture are required. Allow settlements of restitution obligations, which would guarantee an amount of restitution for the victims or go to the victims instead of giving them a false promise of unrealistic restitution orders. In other words, allow the defendant to come to an agreement on the amount of restitution with the victim. And if they're able to pay it, they pay it rather than, having the government make a promise of a, extraordinary high number, which will never be able to be paid. Exempt any reduction in restitution amount owed from being counted as income for tax purposes. So this is all, and should any of this be helpful, the National Association of Criminal Defense Lawyers is very interested, should you have more insight, to connect with them regarding this Fairness and Restitution Act as it begins to collect more steam in an effort to become a law. I hope you found this interesting, helpful. I appreciate you taking the time to listen to this video. And hopefully, if you have a very high restitution, possibly some of what I've reviewed with you through this particular letter put together with the National Association of Criminal Defense Lawyers, their draft, will be a help to you before sentencing, because this is when it has to be nipped. Really, it has to be part of the court's order at the beginning, not at the end. I hope you found this helpful. Stay safe, and I hope everyone has a great day.